We're on.
Good afternoon, everyone. Welcome to Lindsay Taylor Lawyers Lunchtime Seminars. This is the second in our series. My name is Stuart Simington. I'm a partner at Lindsay Taylor Lawyers, and I'm joined by James Fan, Senior Associate in the firm. Today, the title of our presentation is Development Consent Issues, and we're going to be talking about some principles in relation to principles and cases in relation to interpreting consents. So, James.
Thank you, Stuart. Just going to move on to the slides. Pardon me. So, there's a few preliminary matters that we'll go through. The first is that this seminar is being recorded, and for that purpose, we have muted all of the participant mics for the purposes of the recording. If for some reason you become unmuted, then please remute yourself, or we may do this for you. If you have a camera on your computer or phone or iPad, you can turn that off to save bandwidth. You can post questions in the chat box, which we'll show you in just a sec, and we'll answer all those questions at the end of the seminar. The chat box, if you're following us with the 8x8 seminar, is just down the bottom. Just bear in mind that any questions or comments that you post there will be seen by everyone else. For those following us on the YouTube live stream, there's also a chat function, but we'll monitor those and see if there's any questions there too. Thanks, Stuart. Well, let's get started. The topics we're covering today are some of the most contested issues involving development consents. First, we'll be covering the principles of how development consents are construed. When development takes place, whether it's consent for a building works or consent for a use, there's often arguments about what is approved, what restrictions apply, what obligations arise, and to what standards things need to be done. So the construction of a development consent is quite pivotal to all of that. We're then going to talk about the principles that have been set down by the courts. Stuart will then focus on extrinsic materials and how they're incorporated into a development consent, and with some discussion in the Hunter Industries and Dungog Shire Council matter. That's quite a notable Court of Appeal decision where some of the principles that have been set down by the court have been clarified and perhaps somewhat expanded upon. I'll then take you through multiple development consents, where multiple development consents apply to the same land, and we'll talk about the recent Land Environment Court decision in the Department of Planning and Environment against Leader Manistad. So first of all, in relation to the principles of construction, development consent is to be construed according to its terms and having regard to its enduring nature. The fact is that a development consent is attached to land. It's not a right that particularly benefits one person, including its owner. A development consent is a bit like a document of title. It sticks with the land. And so therefore, when construing it, sometimes the court has had to balance what a person might not necessarily know about how a development consent came about. The next principle is that a development consent is to be construed having regard to the fact that it's to achieve practical results and drafted by somebody without legal expertise. There's a big however there, which is the fact that a lot of decisions of the court have emphasised that a development consent is to be construed as though it's a legislative instrument or legislation. And so there are some tips that you need to bear in mind when drafting development consents, and that is, for example, the context in which certain words are used needs to stay the same unless they're defined. The document that comprises the development consent needs to be read as a whole, and where there's an interpretation that results in an absurd or inconsistent interpretation, that's to be avoided.
Yeah, so the courts will pick up a consent, and essentially what we're saying in these examples is the court's going to look at the document as a whole, because it wants to not give any particular condition, for example, a meaning that would be inconsistent with the way that the whole of the document operates. So sometimes the literal meaning of a condition may be interpreted differently than the ordinary definition of the word suggests, if that would make the rest of the document work. And that's why when the courts refer to achieving practical results, the practical result that development consents are seeking to achieve is a sensible planning outcome. So the rules of interpretation are both to say some latitude is given to the drafting of consents because they're assumed not to be drafted by lawyers, but on the same token, the courts will apply the principles of statutory interpretation as applied to other statutes and regulations and so forth.
Thanks, Stuart. The next principle is that a development consent, having regard to the fact that it's an enduring nature, needs to be determined by construing the development consent, including some extrinsic materials, or in limited circumstances. However, plans and other documents which aid the meaning of the development consent will generally always be admissible. So plans, survey plans, markings on plans will generally always be admissible to show what's approved and to what extent something's approved. But we'll go into a bit more detail about that when discussing the Hunter Industries and Dungog Shire decision. The next principle is that as a development consent is a unilateral act of a consent authority, communications between an applicant for consent and the consent authority do not form part of the matrix of documents relevant to its construction. So, for example, if a consultant for an applicant comes along and says, well, we think that development will work this way, unless that's specifically caught up by the development consent as part of a report incorporated into the development consent, those documents generally don't form part of the matrix of documents when construed by the court when there's a dispute about what actually is approved or not approved.
This notion that we've underlined there about unilateral is getting at the fact that the consent is issued by the authority. It's not an agreement between the developer and the consent authority. So it speaks unilaterally as to what is approved. To the extent that the material is not incorporated in it, it's not part of the consent.
Thanks, Stuart. The next principle we'll talk about is that where there's any lack of clarity or certainty in the development consent, it's the responsibility of the consent authority to take that consequence. This arises from a 1970s decision called Roll Ride Homes, where in a development application development consent approving a hospital laundry, the development consent did not incorporate or refer to operating hours, even though the application itself did specify those hours. Unfortunately, when the council sought to take action to enforce those hours, the court said because the council didn't incorporate those hours into the development consent, those hours those hours did not apply, and so the hours of the laundry were essentially at any time or 24 hours a day. That principle has been somewhat set aside by the Hunter Industries and Dungog Shire decision, which we'll go into in just a sec. The next principle we'll discuss is that where a development consent says you can proceed generally in accordance with approved plans, it allows for some latitude and deviation from those plans, but only in relation to a minor nature. But so that essentially says, that principle basically means if you use that, you're essentially opening up a bit of interpretation as to what is or isn't minor, because one person's interpretation of minor may be another person's interpretation of a bit more.
Yeah, so the language generally in accordance with, I think you should really think about whether that is what you're meaning to say when you're approving something. If you use that language, you may well find that there are different results that will be difficult for the council to say are incorrect. It's just much more difficult to run a case where the developer has an enforcement case, I should say, where the developer has the ability to say, there was this latitude. It's much easier to enforce where there are objective standards that can be clearly shown. So think very carefully before you use those sorts of words as to whether that's really what you're intending to permit.
Thanks, Stuart. And we'll then move on to the issue of incorporation of extrinsic documents. Pass on to you, Stuart.
Thanks, James. So we've already mentioned certain aspects of this issue in some of the earlier principles, but the overall issue is that for many years the courts have, I said fought a battle, perhaps it's not a battle, but they've certainly been adverse to allowing reference to be made to extrinsic documents when interpreting a consent. So James mentioned the laundry case with the hours of operation, which was the classic example where the development application which specified the hours wasn't expressly incorporated into the consent document. And that was held, or in that case it was held that it wasn't incorporated or necessarily, it wasn't incorporated expressly or necessarily to be able to be implied as incorporated. And what the courts, the reason the courts have taken this approach was that they said it would be confusing, or it would make it impossible in some cases to interpret a consent if one had to go and locate and review other documents. So we come back to the question about the nature of a consent being a document that runs with the title of the land and not personal to someone or the current owner of the land. And for that reason, the courts want to ensure that subsequent owners can find out what the consent means and how it, without having to go searching, so to speak. But the principle still did allow, as I said, documents to be incorporated if that was done expressly, or if it was a necessary implication of reading the document that some other document was incorporated. And usually those documents that we're talking about that are incorporated will be documents that exist at the time of the development application, although that's possibly not necessarily the case, because consents do envisage that certain new documents being brought into existence after consent is granted, like construction management plans and so forth, and they will, if they're required by a condition, obviously once produced, they can be, depending on how the condition reads, they will become expressly incorporated once they exist. But the key issue was, or has been, that there have been lots of cases about, by and large, about whether one could refer to the development application and the documents that accompanied it. So the case that we we're going to focus on is the recent Court of Appeal decision in Hunter Industries and Dungog Shire Council, where the Court of Appeal, I've said there, has revisited the scope of the restriction having regard to its true, or what the court regards as its true underlying rationale. But that has meant, as you'll see, that the somewhat restricted principles of the court going back 30 or 40 years have been made more practical and flexible, it would be my overall comment. But these proceedings related to some enforcement proceedings brought by the council in relation to the Martins Creek quarry, where there was a new owner of the quarry. The quarry had originally been operated by the rail authority to quarry for railway ballast. And one of the questions in the appeal, not dealt with separately, was whether the consent was limited to quarrying for that purpose, or whether it was a quarry, it could be a quarry generally. But we're more interested in the question about what was incorporated in the consent, insofar as the land was a large parcel, in fact 2 large parcels that adjoining each other, of some 50 odd hectares. And when one had regard to the environmental impact statement, one could clearly see that the proposal had been for quarrying to take place in one particular part of those 2 parcels, and not generally across the 52 hectares. But you could not see that on the face of the consent, and indeed you couldn't see it on the face of the development application form. But as we'll see, the court found a way to revisit this principle and allow the consent to be interpreted by reference to this description of the development in the EIS. If we can go to the next slide, James. So what the Court of Appeal held, in summary, was that it is generally permissible to have regard to the development application to determine the scope and nature of the proposed development. There wasn't this there is no longer, it appears, this restriction that the cases had indicated that one could only do so if it was expressly incorporated, or that was to be necessarily implied from the consent document. And what the court said was that the enduring function of a consent, it wasn't that its enduring function has changed, but its enduring function could be, or can be, achieved even if you have to go to other documents, where those documents are effectively, if they're available to the public. And at the time the subject consent for this quarry had been granted, the EP&A Act did in fact require the council to maintain a public register of consents, including, relevantly, a copy of the development application. So the court basically said, if there's a register of the development application, it's not really going to be confusing or indeed that difficult for a copy of the DA to be found and therefore used to interpret what the consent or what consent has been granted to. There was, in this case, though, a second element or second complexity in that the document which identified where the quarrying could take place was not actually the development application form. It was actually the EIS, which accompanies the development application. And there was a bit of argument before the court as to whether the EIS is part of the DA or accompanies the DA. And that question wasn't resolved or didn't need to be resolved ultimately, because the court in this particular case said that the EIS was in effect expressly incorporated in the DA form, because the DA form had a box on it which says that the full description of the development, put in italics there, could be included in the EIS, and indeed it was. So the court said that the description of the development, by reference to the reference to the EIS on the DA form of that particular application, meant that the description in the EIS was expressly incorporated in the development application, which in turn would be therefore expressly incorporated in the consent. If you can just stick there for a moment. But what the court said again was that the importance of the EIS in the development assessment process was a significant matter, insofar as EISs are exhibited. They're not private documents, available only to the applicant and the consent authority. And therefore, in essence, the court was saying it's quite important that regard can be had to an EIS, even if, and the court, as I said, didn't decide this, even if the EIS is not strictly part of the development application itself, but merely accompanies a DA. It seems as if the court was itching to say an EIS would always be a document that is part of the consent, at least for certain purposes of describing the development. So anyway, therefore the court was able to conclude quite easily in the end that the quarry was limited to the area that the council alleged it to be, and that was that. But the consent, obviously, in this matter was old, and since that time, the regulations about what is meant to be kept by councils and so forth have changed. So what I've done there is just highlight the provisions of the current regulation that bear on this question about what things are available to the public. And in clause 264, you've got it as some particulars of the DA that get kept. But clause 266 requires a council for each development application made to it to keep a copy of the development application. So it seems to me that the rationale that the court was able to use in the case of the Dungog consent is probably it's probably the same under the current provisions of the regulation as it was then. So I think the take-home message is this somewhat restrictive approach to what is incorporated or not it has been emancipated, I suppose, and that shouldn't, though, be a reason not to, when you're drafting, to avoid incorporating the documents that you want to expressly incorporate, or indeed leave out documents that you want to leave out. So condition 1 of the consent is often pivotal pivotal clause, or perhaps it's not condition one in every council's case, but certainly near the front of every consent is a condition which identifies what documents and plans and so forth have been approved expressly, and they will often by omission expressly exclude some of the things that came in with the development application as not being approved, and that's still an important thing to do and to appreciate you are doing when you are drafting a consent.
Thanks, Stuart. I must say that's a very important part of what a consent authority looks for when construing an old consent these days, because a lot of the times consent authority has approved something on the basis of something that was submitted to them, and it could go into quite a bit of detail about how development is to be carried out, and if that ties down how the subsequent use or building is to be carried out, then that's very important to give certainty to those consent authorities to know what's approved. Moving to our next topic, it's multiple development consents where they apply to the same parcel of land. The first principle and the most important principle for this purpose is that there are no constraints on how many development applications a person can make for the same parcel of land, and there can be more than one valid operating consent in existence at any one time, and it's possible to undertake works pursuant to more than one consent at a time. The classic example is carrying out alterations and additions to a building that is already the subject of another consent. And there can be difficulties, particularly where that building hasn't been constructed yet and you're already proposing alterations and additions to it. But this is where multiple consents and whether they can work with each other and the conditions that apply needs to be looked into. So the next principle is that where there are multiple development consents applying, all of the consents may operate unless the implementation of one consent is no longer practical, having regard to what's been carried out.
So on that, if one had one consent to, I often use the example of the steelworks, and another consent for the same land which proposed a council community facility, just as a practical matter, you can't act on the steelworks one and the community facility at the same time because physically it couldn't be done. But that won't always be the case. There will be situations in which it would be possible, if the two consents operate, to act on either or both of them.
Moving on to the next principle. Get the slide.
Steelworks and another consent for the same land which proposed a council.
Just hearing ourselves, unfortunately. The next principle is that a later development consent does of itself take precedence over an earlier consent. Generally, they sit side by side and they're supposed to work in tandem unless, as Stuart mentioned just before, that and the example given that one just simply can't be implemented, having regard to the fact that the other has been implemented too. And so with that in mind, non-compliance with a condition of an earlier development consent constitutes a breach of the Act, particularly where that condition of the earlier consent has ongoing effect. And so we'll then talk about the recent Land Environment Court decision of the Secretary of the Department of Planning and Environment against Leader Manistad. Leader was a residential developer in the north of New South Wales in the Tweed Shire Council area. It was carrying out development in accordance, pursuant to a Part 3A project approval. But Leader was charged with 3 offences of carrying out bulk earthworks in contravention of conditions of that project approval under the former Part 3A. The conditions of the Part 3A approval limited the amount of earthworks and the nature of those earthworks, and the location of where they could be carried out. But at the same time, there were numerous historic and existing development consents that applied, which permitted earthworks across the land. So when it was charged with those earthworks offences, the defence that they ran before the court was that the bulk earthworks was the subject of prior consents. They attributed those earthworks to those prior consents, and they said that the concept approval under Part 3A specifically preserved those prior consents, and so therefore the Part 3A approval couldn't impose limits on those prior consents. They also said that the earthworks were permitted under those prior consents, or a separate consent that was issued after the concept approval and after the project approval, which was independent of it and mutually exclusive of the project approval and not constrained by it. For several reasons, those defences didn't hold up. Justice Pepper held that although prior consents were preserved by the Part 3A project approval, this didn't relieve LEADER of its obligation to comply with the conditions of the project approval of the Part 3A. Rather, it preserved the operations of prior consents only, including the obligation that they imposed in respect of works carried out under them. So therefore, LEADER still had to comply with the conditions of the Part 3A approval, even though bulk earthworks were carried out in the same areas where earthworks were permitted under prior consents. And with that in mind, Stuart and I will just talk about some drafting tips where hopefully with the drafting of conditions and the consent itself, these issues can be avoided going into the future when somebody picks up a consent in the future.
Yeah, so looking perhaps at the last two dot points first, if we can there, James, which essentially follow on from the LEADER case. The key to this issue of multiple consents is that you need to decide which of those consents are to continue when you grant a subsequent consent. And you have the machinery to do that in section 4.17 of the Act, which allows a condition to be imposed requiring the modification or surrender of another consent. So if in approving a new development application, you don't intend for or want action to continue to be able to be taken under an earlier consent, you should impose a condition requiring, in certain cases, the entire surrender, or maybe it's the modification of the consent. So the modification of that earlier consent could be required so that it hitherto only operates in relation to land to which the new consent doesn't apply. But whatever it may be, when you grant a new consent, you can't just forget about the other ones that exist. You've actually got to interpret them, understand what they approve or require, and include that in the conditions that you draft for the new approval. Now, I don't know, in my experience, this provision of the Act is not well appreciated. People either don't know it's there or don't utilise it as much as they should. But the point is that you need to and you should make sure that there is no inconsistency, and indeed that the inconsistency has been resolved by surrender or modification.
Thanks, Stuart. The other tips when drafting consents and conditions are, where appropriate, define terms and use that language consistently. It's no use having certain phrases in some portions of condition 1 and then elsewhere in condition 100 and whatever have that somewhat contradictory and have somebody essentially have to scratch their heads as to what was what that term relates to, or in a different aspect. And to pick up the point from the the Hunter Industries and the Dungog decision, is to be careful as to specify the documents that you intend to incorporate or leave out, because this is particularly important where there are reports submitted by an applicant that describes the proposed development. If you incorporate some documents but then leave out some, you can have a different result to what happened in the Dungog decision, where the court may say, well, you incorporated some documents that say how the development's to be carried out, but then you didn't incorporate others which perhaps may have been more specific or gave more detail to how that development is to be carried out. So if you've incorporated some but left out others, it does create a bit of confusion for a subsequent person, or indeed the court, to ask itself what the development actually approves. So they're the tips that we had today, which leaves time for questions. So if anybody has any questions, feel free to type them into the chat box, and I'm just going to have a look at them here. Has anybody got any questions? It's all silent.
Well, that's fine. We can wrap it up then for today. Thank you for tuning in, and we intend to have a series of seminars. We'll let you know as and when they will be happening, and I hope today has been informative for you, and we'll see you next time.
It looks like we've got a question just come up. Michelle McLennan, have you got a question that perhaps you might want to just put yourself off mute and come say your question? No. Well,
Michelle, we're not sure if you're trying to ask a question or not, but if you were and you weren't able to, feel free to give us a call or drop us an email, and we'll endeavour to deal with that, because we can't hear you at the moment or see your question. But
we've started to get a few questions filtered through now. From Denise, we've got a question. An old development consent from 2006 references operations, hours of operation, in a cover letter to the DA, but nowhere else referenced in the DA determination material. What do you think, Stuart? Is that Royal Ride Homes, or is that Dungog?
Yes, well, the cover letter, as the word cover tends to imply, means that I would have thought that it's quite likely that the court wouldn't regard the cover letter as part of the actual application. But then again, if the development application, if the cover letter becomes part of the register itself that the council keeps, well, perhaps you could argue the other way. But that's a good question. It just shows that none of these issues are ever simple, but highlights also what we said, that incorporate the document or write a condition which reflects it.
Yep. Next question is from Graham. He asked, are multiple CDCs treated the same way as a DA? The short answer is yes, unless the CDCs are implemented in a way that essentially forces the other CDCs to not be able to be implemented. Yes, you can have multiple CDCs applying to the same parcel of land, and they could be doing contradictory things too. But once somebody perhaps implements those CDCs, that essentially causes other CDCs to be incapable of being implemented, then that's where you might have you can't implement all of those. Next question comes from our live stream. It's from Stephen. He asks, when a previous consent is modified by section 4.17, this takes effect. Should you issue a new consent when the notification is lodged with council?
So, as I understand the question, Stephen, the physical process or the legal process of responding to a condition of a consent that requires the modification or a surrender is set out in clause 97 of the regulation. What it basically involves, for those who haven't looked at that before, is that the developer files a notice with the consent authority implementing the surrender or the consent, and once the notice is received and by the council, I think it operates automatically to affect the surrender or the modification, as the case may be. So there's no process of reissuing the consent at that point. What there is the consent that was issued and the notice, which will end up on the council's file, which tells you what's been surrendered or modified. So essentially, the surrender notice or the modification notice becomes, part of the earlier consent that has been surrendered or modified.
And Stephen has a follow-up to that. And since it takes effect, I'm assuming the surrender takes effect when it's lodged, if council is not satisfied with what is submitted, say amended plans, can council have another crack at asking for a new plan?
Well, the condition, Stephen, of the consent, which requires the modification or the surrender, should not be a matter that has any ambiguity about it. So, it could be the condition of the 4.17 condition could say, for example, the consent number 123 of 2000 is to be modified by deleting condition 4. And there's no question of plans or so much being lodged. It's just a question of that happening. If the modification, I'm just trying to understand, in a sense, how one would have this situation arising whereby plans are called to be drafted, but I suppose it could be done if you were to say, if the condition, for example, was to say that the earlier consent is to be modified by a plan, by amendment of condition 1 to substitute for plan such and such a plan that achieves such and such, and so the plan would be lodged, supposedly implementing the such and such, and there might be a question about whether it does that. I think at that point the answer would be, well, there has to be a determination as to whether it does or does not do such and such, and if it doesn't do such and such, then the notice of lodged with the council wouldn't be effective.
Thanks, Stuart. We've got another question here from Sam. He asks, do you think it's worthwhile dragging important operational issues out of SEE and specifically conditioning them if the SEE is listed in conditions such as ours? My thought is that if you've already incorporated the SEE, then you don't need to specifically do that. If you say that development is to be carried out in accordance with certain documents. But where you need to do that is where you're approving development that may be different to what has been set out in the SEE. Yeah. So, for example, if the applicant has set out all of the reasons or all of what's proposed and for some reason the council doesn't agree with specific aspects of it, then you really do need to, aside from incorporating the SEE, have separate conditions that say what.
Oh, and by the way, you can't do that. That is in the SEE.
Yeah.
So that's the thing. If you don't agree with everything in the application, you have to be careful to exclude things. And so I think the key. A good way of going about the drafting is for the conditions to cover the key issues of concern to the council so that there can be no doubt about the fact that they are requirements, whether it's hours of operation or limits on noise or whatever it is. To rely on just saying the SEE is approved, it may work, but I think it's better practice to pull out those things and specifically deal with them if you can. And that's what I think is the practice of most councils, but certainly with older approvals in places, you often didn't see that. So,
and there's a follow-up from Stephen about multiple consents. He asks, he says his example was referring to a component of a development. Is where a component of a development is to be deleted. It could be built form, I assume, or a particular use. But if a component of development is to be deleted, then it may be the case that conditions can deal with that by modification of the earlier consent, by imposing certain conditions that deal with that.
I'm just not sure. And is the question, James, I can't see the question, but is it that a new application is received to delete a component of an existing development consent? Is that the context?
Well, it's going back to the original question. It's where where a previous consent is modified by section 4.171B, and this takes effect should you issue a new consent when the notification is lodged.
And we've already said no to that.
Yeah.
I think if I might be misinterpreting, I can't see what James is reading expressly, Stephen, but it seems to me that where the component of the earlier development is to be deleted, all you need is that notice of modification, and you then have the old consent and the notice of modification. The two documents, they work together, just like you would when you issue a section 4.55 approval. Although some councils do it, strictly speaking, you don't need to reissue the consent itself. The two documents, the original consent and the modification, sit side by side, and you interpret them together. So, I don't know if that answers your question, but hopefully it did.
Okay. All right. Well, thanks for those questions. But as Stuart mentioned, we can always take questions after this seminar. We're always available by phone or email. But last thing is to just note that with our seminars, aside from our seminars that we're carrying out in these lockdown times, is that we're keeping our Lindsay Taylor Lawyers in Focus blog up to date with recent amendments to environment and planning local government laws. So always a source of information on recent legislative amendments, introduction of policies and so forth. So keep an eye out for that. And if you're not subscribed, make sure you do so.
Thank you very much. We'll hopefully see you on at the next seminar.
Thank you.
Good afternoon.